Buried inside the very proclamation the White House used to justify a 50% tariff on Canada sits a number that quietly undercuts the entire argument for imposing it. The administration's own text states that between April 2025 and February 2026, while Washington and Ottawa were locked in escalating tariff combat, Canadian imports of American motor vehicles fell sharply. And in that exact same window, Canadian purchases of vehicles from Mexico jumped by roughly 23.5%. Purchases from Japan, Korea, and Germany rose somewhere between 10 and 13.5% each. And altogether, Canada redirected close to $2.85 billion in vehicle purchases away from the United States and toward its competitors, with Mexico alone soaking up nearly $2 billion of that total. That is not an outside critic's estimate. That is language sitting inside the government's own Federal Register filing, the exact document used to justify invoking a tariff weapon that had been sitting untouched since 1949. The tool was supposed to punish Canada into reversing course. Instead, the government's own paperwork documents that the market share was already gone, rerouted permanently to Mexican, Japanese, Korean, and German manufacturers before the new 50% duty ever took effect. That is what it looks like when a trade weapon fires and hits the hand holding it. And it is only the beginning of a much bigger story about how, 4 separate times in under 18 months, the search for a legal tariff authority that could actually survive has led the administration further and further into a corner it built for itself. Let's go back to where this entire chain of events actually starts, because you cannot understand why a 96-year-old statute ended up as the tool of last resort without walking through everything that came before it and everything that got struck down along the way. In April 2025, the administration rolled out what it called Liberation Day tariffs, a sweeping near-global set of duties imposed under the International Emergency Economic Powers Act, a 1977 law originally written to let a president freeze assets and block financial transactions during genuine national security emergencies. It became the broadest unilateral tariff action in American history at that point, hitting dozens of countries simultaneously with reciprocal rates and separate duties tied to fentanyl trafficking, concerns aimed specifically at Canada, Mexico, and China. Businesses sued almost immediately. States joined the fight that spring. And on February 20th, 2026, the Supreme Court delivered its verdict in a 6-3 decision, ruling flatly that IEEPA does not authorize a president to impose tariffs at all, striking down both the reciprocal tariffs, hitting most of the world, and the fentanyl-related tariffs targeting Canada, Mexico, and China specifically. The ruling was unequivocal. It didn't carve out exceptions or invite a narrower version of the same approach. It simply said the law never granted this power in the first place, and it did so in the exact same underlying legal framework the administration would need for whatever came next. Subscribe now if you want the full picture on how a legal defeat becomes the launch pad for an even riskier gamble, because what happened over the following 6 months is a masterclass in exactly that pattern. Within days of that Supreme Court ruling, the administration pivoted to Section 122 of the Trade Act of 1974, a narrower statute that lets a president impose a temporary tariff surcharge of up to 15% specifically to address a genuine balance of payments emergency. On the same day the Supreme Court struck down IEEPA, the administration signed a new proclamation invoking Section 122, imposing a flat 10% global tariff. And this detail matters enormously because Section 122 comes with a hard built-in expiration, 150 days full stop unless Congress votes to extend it. That clock started on February 20th and was set to run out on July the 24th, 2026. States sued again almost immediately, and this time 24 of them, joined by the Liberty Justice Center on behalf of importers, argued in a case filed at the Court of International Trade that the statutory conditions required to invoke Section 122 had never actually been met, because there was no genuine large and serious balance of payments emergency to justify it in the first place. On May 28th, 2026, the Court of International Trade agreed. It found that the United States did not have a balance of payments problem as defined under the statute, and it ruled the Section 122 tariffs unlawful. That ruling is currently under appeal, but the practical reality is this. A second tariff tool, deployed specifically as the emergency backup plan after the first one collapsed, also got struck down by a federal court within roughly 3 months of being signed. Here's your first thing to really sit with, because it explains why the administration's next move happened with such striking speed. Section 122 wasn't just any backup plan. It was Congress' own historical answer to exactly this kind of presidential overreach. Back in 1971, President Nixon invoked a different law, the Trading with the Enemy Act, to impose a similar 10% import surcharge. and that action wound up in federal court in a case known as Yoshida, which eventually forced Congress to sit down and explicitly write a narrower, more constrained tariff authority specifically so that a future president couldn't simply reach for open-ended emergency powers to tax imports at will. That narrower authority, deliberately built with guardrails and a hard time limit after almost 2 years of congressional debate, was Section 122 itself, enacted in January 1975, which means the very statute Congress created half a century ago to prevent exactly this kind of unchecked tariff maneuver became, in 2026, the second tool used to attempt exactly that maneuver. And it failed the same historical test it was originally designed to enforce. The Court of International Trade's ruling in May explicitly walked through that Yoshida history in its opinion, tracing the direct lineage between Nixon's 1971 surcharge and the Section 122 authority Congress, built specifically to prevent a repeat. History doesn't often circle back this precisely, but this is about as close as trade law gets to watching the same argument play out twice, 50 years apart, with the same outcome both times. With Section 122 legally wounded and its statutory clock running out regardless of the appeal, the administration needed something that could take effect the instant that 10% global tariff expired on July 24th. And it needed two things simultaneously: speed and legal durability. A combination none of the previous tools had actually delivered. What it landed on was Section 301 of the same 1974 Trade Act, but used in a fundamentally different way than its most famous prior application. Back in March 2026, just weeks after the Supreme Court's IEEPA ruling, USTR self-initiated investigations into 60 of America's largest trading partners, examining whether each government had failed to adequately ban or enforce a ban on the importation of goods made with forced labor. Over the following months, USTR collected more than 1,600 public comments, held multiple days of hearings, and by June 2, 2026, announced affirmative findings against every single one of the 60 countries under review. On July 23rd, the tariffs became official, 10 or 12.5% stacked on nearly everything, covering economies that together account for 99.4% of all American imports, and taking effect the moment Section 122 expired, in the same minute, without so much as a gap in coverage. Here's the part almost nobody fully connected together when this happened, because it moved so fast that most coverage treated it as a routine trade announcement rather than what it actually was, a legal insurance policy against the possibility that Section 301 might not hold up either. The Peterson Institute for International Economics, reviewing the forced labor investigation's actual record, published an analysis concluding these tariffs are unlikely to survive a court challenge, pointing out that the Court of International Trade had already found the government lacked a genuine statutory basis once this year under Section 122, using strikingly similar reasoning about whether the underlying factual justification actually matched what the law required. And, right on schedule, on August 3, 2026, a coalition of 25 states filed suit at the Court of International Trade, challenging the Section 301 forced labor tariffs directly, arguing the administration exceeded its authority by imposing sweeping duties on 60 trading partners in what the complaint describes as a nearly uniform outcome that doesn't rationally correspond to each country's actual, individually documented forced labor record. New York Attorney General Letitia James put the pattern into words that landed with real weight. After losing at the Supreme Court, she said, the administration is once again trying to illegally raise taxes on families and businesses with a new round of tariffs. This isn't the first time she said something close to that, it's the third. Quick pause here, because if breakdowns like this, ones that actually trace how a legal defeat in February turns into a new tariff scheme by July, help you see the pattern before the headlines catch up, go ahead and hit subscribe. Because the fourth chapter in this story, the one buried in a statute from 1930, is where the phrase trapped actually starts to earn its place in this title. While Section 301's court fight was still forming, the administration had already reached for a fourth and final tool. And this is where the 96-year-old weapon comes back into frame directly. On July the 20th, 2026, President Trump signed 3 separate proclamations, invoking Section 338 of the Tariff Act of 1930, a statute that had not been used to impose a single tariff since 1949, aimed specifically at Canadian motor vehicles, dairy products, and alcoholic beverages, each carrying an additional 50% ad valorem duty, effective August 19th, 2026. Trade analysts tracking this decision were blunt about exactly why Section 338 got chosen over every other available option. Section 301 requires a formal USTR investigation. Section 232 requires a national security finding from the Commerce Department. Section 338 requires neither. The president can act by proclamation alone. No investigation, no hearing, no waiting period beyond the statute's own mandatory 30-day notice window before collection can begin. Following the Supreme Court's ruling against IEEPA in February, that simplicity became the entire appeal. It was fast. It required no agency process that could itself be challenged as procedurally deficient, and it came with a 50% cap that conveniently matched what the administration had already been trying to achieve through every prior tool. But that same simplicity is precisely what makes Section 338 legally shakier than almost anything the administration has tried so far, and this is the detail sitting at the absolute center of why this weapon may already be backfiring in real time. The statute doesn't just let a president act unilaterally. It specifically charges the International Trade Commission with a duty to ascertain and continuously monitor whether discrimination against American commerce exists, language that reads, on its face, like a requirement for a formal investigative finding before any proclamation can be issued. No such ITC investigation happened before July 20th. The administration's legal position rests on a different clause in the same statute, one allowing the president to act whenever he shall find as a fact that discrimination has occurred, which several trade law analyses now argue may not require the ITC's involvement at all, creating exactly the kind of internal statutory contradiction that federal courts tend to find irresistible. One trade law analyst tracking the announcement in real time, writing the day after the proclamations were signed, offered a genuinely revealing prediction about what the administration itself might actually believe about its own legal footing. Rather than expecting the 50% tariffs to simply take hold and stay in place, this analysis predicted a series of rolling 30-day extensions instead, using the threat of the tariff as negotiating leverage inside the ongoing USMCA review process, rather than as a durable, permanent duty structure. If that reading is right, and if that's genuinely how confident the administration itself is in Section 338's staying power, this fourth tool may already be functioning less like a stable tariff regime and more like a countdown clock designed to expire and reset indefinitely, never quite tested in court long enough for a ruling to actually land. That legal vulnerability sits directly on top of a second layer of vulnerability, and this is where the story's opening detail comes back around, because the tariff's own justification document contains the clearest evidence yet that this specific weapon has already done real, permanent damage to the exact interest it was supposed to protect. The Motor Vehicle Proclamation argues that Canada's surtax on non-USMCA compliant American vehicles, itself a retaliatory response to earlier American steel and aluminum tariffs, constitutes unlawful discrimination against American commerce. To support that claim, the proclamation lays out exactly how much damage that Canadian surtax has already caused, and in doing so, it inadvertently documents something far more troubling for anyone hoping this new 50% tariff actually reverses the trend. Canadian imports of American vehicles didn't just decline. The market share those American exporters lost got picked up almost entirely by Canada's other trading partners, immediately and durably. Mexico gained roughly $2 billion of that shift on its own. Japan, Korea, and Germany split most of the rest. Manufacturing capacity, once redirected toward serving Canadian demand from a Mexican, Japanese, Korean, or German assembly line instead of an American one, doesn't snap back the moment a new tariff gets signed in Washington. Supply contracts get renegotiated. Dealership relationships shift. Consumer habits adjust. A 50% duty imposed in July 2026 does nothing to claw back trade volume that had already permanently relocated by February. The tariff arrived to punish a wound that had already scarred over in exactly the shape of Canada's competitors. This is the trap the title of this story is really describing, and it operates on two separate levels simultaneously. The first is legal. 4 different statutory authorities have now been deployed in roughly 18 months: IEEPA, Section 122, Section 301, and Section 338. And each one has either already been struck down, is currently facing active litigation from state coalitions with real standing and real financial injury, or is openly predicted by trade law analysts to be used more as rolling negotiating leverage than as a tariff anyone expects to survive sustained judicial scrutiny. Every time one tool fails, the next one reached for is narrower, faster to deploy, and paradoxically, more legally exposed, because narrower statutes written for narrower emergencies tend to come with narrower interpretive room once a court actually sits down to read them closely. Section 338's own defenders inside the administration chose it specifically because it skips the process. But skipping the process is exactly the kind of shortcut federal courts, particularly the Court of International Trade, have shown a clear and consistent willingness to punish this year, twice already, on strikingly similar reasoning each time. The second level of the trap is economic, and it's the one that shows up on the ground long before any court issues a ruling. Every time a new tariff wave lands, it doesn't just tax the targeted country's exporters. It sends every other supplier in that market a permanent signal that American supply cannot be relied upon. And once that signal gets absorbed into a Mexican, Japanese, Korean, or German manufacturer's long-term planning, into a Canadian retailer's sourcing contracts, into a Canadian consumer's brand loyalty, it tends to stay absorbed regardless of what happens to the tariff itself down the line. That is precisely what the administration's own Section 338 proclamation documents happening with Canadian auto purchases. It is a pattern that shows up again and again across this entire 18-month stretch. In Canada's roughly 81% collapse in American alcohol purchases after provinces pulled American liquor off government shelves, and the broader restructuring of Canadian trade relationships toward the European Union, the United Arab Emirates, and Ecuador that accelerated specifically because Ottawa could no longer treat American market access as a stable, permanent feature of its economic planning. Tariffs designed to punish a trading partner into compliance instead teach that trading partner and every other country watching from the sidelines to build permanent alternatives, and permanent alternatives, once built, generally outlast whatever legal fight eventually resolves the tariff dispute that triggered their construction in the first place. There's a third dimension to this trap that deserves its own honest accounting, because it's the one that shows up directly in household budgets rather than in trade statistics or court filings. Independent tax policy analysis, tracking the combined weight of this year's tariff actions, layering the Section 232 steel and aluminum duties still in place, the various IEEPA and Section 122 measures that cycled through earlier in the year, and now the Section 301 and Section 338 layers on top, estimates the average household cost of 2026's tariff policy at somewhere close to $900 per family, quietly embedded across vehicle prices, grocery bills, and construction materials. That cost accumulates regardless of which specific statute a court eventually strikes down, because once a tariff has been collected at the border and passed through a supply chain into a final retail price, reversing that cost after the fact requires a refund process that has already proven remarkably difficult to execute cleanly. The Court of International Trade is scheduled to hear oral argument on August 6, 2026, on a motion seeking to certify a nationwide class of importers owed refunds from the already invalidated IEEPA tariffs, specifically because thousands of businesses would otherwise be forced to file duplicative individual lawsuits just to recover money the government has already been ordered to pay back. Customs and Border Protection built a portal for processing those refunds, but access currently depends on the liquidation status of each individual entry. A bureaucratic tangle that means winning in court and actually recovering the money owed can be two entirely separate battles fought months or years apart. That is what genuinely trapped looks like from the perspective of an ordinary importer. Even when the legal system agrees you were wronged, getting made whole again is its own extended fight. Zoom out far enough, and the shape of the entire 18 months comes into focus as something closer to a slow-motion demonstration of diminishing returns. There's a piece of this story that deserves its own closer look, because it explains why the administration keeps returning to Canada specifically as the primary target across 3 of these 4 separate legal authorities, rather than spreading the pressure evenly across every trading partner simultaneously. Canada occupies a genuinely unusual position in American trade policy, because unlike most of the 60 countries swept into the Section 301 forced labor action, Canada sits inside a formal, ratified free trade agreement with the United States, one that took years to negotiate and that the current administration itself signed during its first term. That should, in theory, make Canada one of the hardest targets to tariff cleanly, since USMCA was specifically designed to lock in duty-free treatment for qualifying goods regardless of whatever else happens in the broader trade relationship. And yet Canada has now absorbed direct hits from Section 232 steel and aluminum tariffs, from the original IEEPA fentanyl and reciprocal tariffs before they were struck down, from the Section 122 global surcharge before that too was struck down, and now from Section 338, specifically because Section 338 was drafted with language explicitly stating that its duties apply even to goods otherwise qualifying for USMCA preferential treatment. That detail alone tells you something important about how this administration views the limits of existing trade agreements. A signed, ratified agreement, even one bearing the current administration's own signature from years earlier, does not appear to function as a hard ceiling on what a subsequent proclamation can reach past, provided the legal authority invoked is broad enough or old enough to sidestep the agreement's own protective language. That pattern connects directly to the broader USMCA story unfolding in parallel this year. On July 1st, 2026, the USMCA Free Trade Commission held its mandatory 6-year joint review, the built-in checkpoint written into the agreement requiring all 3 governments to confirm whether they want to extend the deal for another 16 years. Canada and Mexico both confirmed. The United States did not, with USTR Ambassador Jameson Greer stating plainly that the United States did not agree to renew the agreement in its current form, a decision that triggers a new annual review process running all the way toward the agreement's original 2036 expiration unless all 3 parties eventually agree otherwise. The Section 338 proclamations landed just 19 days after that joint review meeting, and the timing tells its own story. Rather than waiting for a full renegotiation process that could take years, the administration reached for a tool capable of achieving similar leverage over Canadian trade in a matter of weeks, using a statute that requires no partner country's signature and no multilateral consensus, just a single presidential proclamation with a 30-day countdown attached. USMCA remains technically alive, its 16-year term still running on paper, but its practical function as a reliable shield for Canadian exporters has already been demonstrated, twice this year alone, to depend entirely on which statute the White House happens to be using at any given moment. This is exactly why so much of the trade compliance community has spent the past several weeks describing the current moment less as a stable policy environment and more as a continuously shifting legal landscape that businesses have to track, almost in real time. Companies that spent 2025 building compliance frameworks around IEEPA had to tear those frameworks up in February when the Supreme Court struck the law down entirely. Companies that pivoted to planning around the Section 122 global surcharge had to revise everything again in May when the Court of International Trade ruled that authority unlawful too, and again in July when the statutory clock simply ran out regardless of the pending appeal. Companies now trying to model their exposure under Section 301's 60-country forced labor tariffs are simultaneously watching a 25-state lawsuit that could unwind that framework as quickly as the previous two collapsed. And companies specifically exposed to Canadian trade are watching a fourth authority, Section 338, that carries its own open legal question about whether it was ever properly invoked in the first place, layered on top of an active, unresolved renegotiation of the underlying trade agreement that was supposed to provide certainty in exactly this kind of situation. Predictability, the single thing supply chain planning depends on most, has been the first and most consistent casualty across all four of these legal experiments, regardless of how any individual court case eventually resolves. What makes this particular moment feel different from earlier tariff disputes in recent memory is the sheer compression of the timeline. Trade agreements traditionally took years to negotiate, and historically, roughly as long to unwind when disputes arose, giving businesses on both sides of a border realistic time to adjust sourcing, renegotiate contracts, and find alternative suppliers without catastrophic disruption. What's happened over the past 18 months compressed four entirely separate legal theories, four Supreme Court and Court of International Trade proceedings, and four distinct waves of tariff exposure into a period barely longer than a single fiscal year. Businesses that adjusted their sourcing in response to one authority found themselves needing to adjust again within months when that authority collapsed and a new one took its place. That compression is itself a form of economic damage, separate from the tariff's actual dollar cost. Because uncertainty of this magnitude discourages exactly the kind of long-term capital investment in new manufacturing capacity, new supplier relationships, new distribution infrastructure, that actually determines whether American industry gains real ground against foreign competitors over the coming decade, rather than simply shuffling which specific statute happens to be collecting duties at the border this particular month. IEPA offered the broadest possible reach and collapsed under the broadest possible legal challenge, a unanimous 6-3 Supreme Court ruling that left no room for a narrower version of the same argument to survive. Section 122 offered a built-in time limit and a narrower factual predicate, and it collapsed just as fast, struck down by the same court whose reasoning traced directly back to the exact congressional debate that created the statute in the first place, a debate born from an earlier president's own failed attempt at unilateral tariff power 50 years earlier. Section 301 offered procedural legitimacy, formal investigations, formal comment periods, formal hearings, the very things a court typically wants to see before deferring to an agency's judgment, and it is now facing a 25-state lawsuit, specifically arguing that all of that formal process produced a predetermined, near-uniform outcome that never actually engaged with the 1,600 comments submitted against it. And Section 338 offers speed above everything else, skipping the investigation entirely, and in doing so, walks directly into the exact kind of procedural vulnerability that speed was supposed to avoid, an open statutory question about whether the International Trade Commission's own ascertainment duty was ever satisfied before the president acted. Four tools, four different statutory theories, four different legal weaknesses, each one distinct, each one now sitting in front of federal judges in overlapping, simultaneous litigation. That is not what a durable, sustainable trade policy looks like from any legal perspective, regardless of which side of the underlying trade debate anyone actually sits on. It looks like a search that keeps finding faster doors and keeps discovering that faster doors lead to thinner legal ground. And every time a faster door gets tried, the economic damage on the other side of it, the permanently rerouted vehicle purchases, the permanently abandoned alcohol shelves, The permanently accelerated diversification efforts in Ottawa, Brussels, and beyond has already happened by the time any court gets around to ruling on whether the door should have been open in the first place. What happens between now and August 19th, when the Section 338 tariffs are scheduled to take full effect, is genuinely uncertain in a way that few trade stories this year have actually been. Litigation. Challenging Section 338 specifically is widely expected, but has not yet been filed as of this recording, meaning the 50% duty may well take effect on schedule even as legal challenges gather momentum behind it. Exactly the same pattern that played out with Section 122 earlier this year, where tariffs collected and passed through supply chains for months before a court finally ruled them unlawful, leaving businesses to fight a separate, drawn-out battle just to get that money back. Every one of the earlier three tools followed a nearly identical rhythm: months of collection, a wave of litigation, and only then, sometimes half a year or longer later, a ruling that arrives well after the practical economic damage has already settled into place. If the pattern holds, and if the 25-state coalition currently challenging Section 301 achieves anything close to what it achieved against Section 122 back in May, the administration may find itself searching for a fifth legal tool sometime in the coming months, because Section 338 itself contains its own built-in escalation clause, explicitly authorizing the president to move toward a full import ban if Canada is found to maintain or increase what the statute calls its discrimination, a ratchet that only tightens and never loosens on its own. That is the trap, closing from both directions at once. Legally, every available tool has now been tried, and every available tool has produced a court fight, a court loss, or credible predictions from trade analysts that even the administration itself doesn't expect this particular version to hold. Economically, every tariff wave fired so far has produced the same durable side effect regardless of its eventual legal fate: permanently redirected trade flows that don't reverse just because a proclamation gets amended or a court eventually strikes something down. The 1930 statute that sat quietly on the books for 96 years was reached for specifically because it promised to be the fastest, cleanest option left on the shelf. What its own supporting paperwork actually reveals is a country that has already paid the economic price for this fight in permanently rerouted trade is now facing its fourth simultaneous legal battle over the tools used to wage it, and has, by its own admission, inside its own proclamation, documented the exact moment its own leverage quietly ran out, long before the 50% duty it was meant to justify ever reached a single border crossing. If this breakdown helped you see how 4 separate tariff tools in 18 months add up to something much bigger than any single headline captured, hit subscribe so you catch whatever comes next once the Section 338 deadline arrives, and the refund fights currently working through the Court of International Trade start producing real rulings. Drop a comment below and tell me which of these 4 legal authorities you think was the administration's strongest bet, and share this with anyone who still thinks this trade war has been one continuous policy rather than 4 separate attempts, each one narrower than the last, each one carrying its own price tag that doesn't disappear no matter how the legal fight eventually ends. The weapon fired 4 times in 18 months, and each time, the paperwork used to justify pulling the trigger ended up documenting exactly how much ground had already been lost before anyone in Washington ever noticed the trap closing around them.